From the Library of Congress in Washington, D.C.
Good afternoon, everyone. I am Carolyn Brown. I direct the Office of Scholarly Programs and the John W. Kluge Center here at the Library of Congress. And it gives me great pleasure to welcome you here this afternoon for today's lecture by Dr. John Witte Jr. entitled Sharia in the West: What Place for Faith-Based Family Laws in Liberal Democracies? But before we begin, I'm going to ask you if you would turn off your cell phones or anything that's going to beep, bong, or otherwise make noise and interfere with our speaker or the recording. Today's event is co-sponsored between the Kluge Center, the library's Law Library, and the African and Middle Eastern Division. And it's always a great pleasure to do these sponsored lectures with our colleagues because it reminds us that we are doing one of the things we hope to do, which is to bring together thinkers who are working at the intersection of a number of disciplines. A few brief words about the Kluge Center. The center was established through a very generous endowment by John W. Kluge, to bring together some of the world's most mature minds and thinkers and create opportunities for conversation with policymakers, and also at the other end of the career spectrum, to make opportunities for some of the world's most promising junior fellows to come to the library for their research and to create a community between these two groups. The center also sponsors lectures such as this one. All of our postdoc fellows give some sort of public presentation. And if you'd like to know more about the kinds of things the Kluge Center does, I invite you to sign up in the back for an RSS feed so you can get email notifications. And there's also a brochure about the center. Today's speaker, I'm happy to say, is a not exactly long-time friend of the Kluge Center, but a very intense friend of the Kluge Center, and you'll know what I mean pretty soon when I say intense. When he's not at the Kluge Center, which he isn't at the moment, he is the Jonas Robitscher Professor of Law, Alonzo L. McDonald Distinguished Service Professor, and Director of the Center for the Study of Law and Religion at Emory University. But that close association I was talking about, John just left, I guess, in mid-October. Until mid-October, for several months, he had been the Cary and Ann Maguire Chair in Ethics in American History. He's also a member of the Library Scholars Council that advises the librarian on issues related to scholarship and academia, and that council meets once a year. So he'll be back in May. And he'll also be back to give his official Maguire lecture sometime in the spring. So that's why I said an intense relationship, which is totally wonderful. We love having him here. And actually he was here another time earlier, just as a visiting scholar, and I captured him for help with a program at the last minute. So I consider him a great friend and supporter. But in addition to that, and the main reason you're here, is that he is a prolific scholar. He's published 26 books, 220 articles, and 15 journal symposia. I now know what those are. They're collections of papers from a symposia that are brought together. It's a term used by lawyers, so I thought I knew academic terminology, but I didn't. His major areas of research, which of course is what you're interested in, are legal history, religious liberty, marriage and family law, human rights. And to these issues, he brings a deep historical grounding. Not all lawyers think historically. as well as clearly the tools of legal history and analysis and a very rich knowledge of Christianity. And I just want to give you a flavor of his background from the titles of some of the books. Sex, Marriage, and Family Law in John Calvin's Geneva. God's Joust, God's Justice, Law and Religion in the Western Tradition. Christianity and Law, an Introduction. Sins of the Fathers, The Law and Theology of Illegitimacy Reconsidered. Christianity and Human Rights, an Introduction. Religion and the American Constitutional Experiment. I think that gives you a pretty good sense. In addition, though, to all of his writings, he's directed 12 major international research projects on democracy, human rights, religious liberty, and marriage, family, and children. As you can imagine, he's won a number of teaching and research awards, but probably the one that was hardest to accomplish, for those of you who know law schools and law students, was that 11 times he's been selected by the Emory law students as the most outstanding professor. He's taken up a really interesting subject today, the tension between religious and secular law in liberal democracies. So please welcome John Witte.
Well, thank you so much, Dr. Brown, for your very warm and very generous introduction. I should just sit down. I think it's all downhill from here. I appreciate so much your kind words. Thank you so much for taking the time to be with us this afternoon. This has been a rain-soaked and anxiety-filled week, and I know it's nice to come here and have a relaxing talk about a little thing like Sharia in the West, just to kind of take it easy, but I especially appreciate the opportunity to be in conversation with you. Thank you so much for being here. It's wonderful to be back at my intellectual home, away from home, at the Kluge Center, where I understand I'm an intense visitor, certainly a very happy visitor. I've had the joy of being here a couple of times, especially this last 4 months in the summer, and dipping deeply into the Library of Congress's collection and having a chance to interact with the wonderful bevy of scholars that the Kluge Center brings together so compatibly. I want to say a special word of appreciation and admiration to Dr. Brown for her kindness in having me here and for leading such a wonderful resource, an intellectual resource for the community and for the Academy. I also want to recognize and thank and appreciate the work of the Kluge Center team that make visitors like me feel so welcome. Mary Lou Raker, Evelyn Small, Joanne Kitchen, Jason Steinhauer, Sally Aronson, and Denise Robinson were amongst the folks to try to keep me in line in the course of this summer, and I've enjoyed being with them. It's been a special joy to sit in the plush luxury of the Anna Maguire chair. Only 4 months, of course. I'm not worthy, but sitting there even for 4 months has been a wonderful treat, and I appreciate the Maguire family deeply for their endowment, and when they listen in on the DVD, I hope they're smiling. I also want to especially thank the librarian, Dr. James Billington, for his kindness in having me here again at the center. As you heard, I work on issues of law, religion, and family in the Western tradition and today, and these are amongst the most controversial and divisive questions that now occupy us in America and indeed around the world. The headline issues, as you know, are about issues of the form of marriage. Straight marriage versus gay marriage, contract versus covenant marriage, domestic partnership or civil union versus state-sanctioned marriage. Just over the horizon are issues of monogamy and polygamy. A little further down the horizon, coming up when I'm an old man, I think we'll be dealing with issues of incest versus exogamy and polyandry more generally as recognized legal categories in the domestic relations field. These are issues I'll touch on a bit today, but I want to deal with a related question that touches another issue of law, religion, and family. It's not about the form of marriage, but it's rather about the forums in which marriage and family questions get adjudicated today, and the growing push that we're seeing in various parts of the West toward the recognition and use of faith-based family laws. Out of respect for you and out of fear and trembling to stand before Dr. Brown with ad lib remarks only, I've actually prepared a text I've got 42 and a half minutes. If you are getting uncomfortable, start wincing and moving uncontrollably, and I will shave a few pieces off so we can move the conversation, which is the real heart of what we're about. On February 7, 2008, Anglican Archbishop Rowan Williams set off an international firestorm by suggesting that some accommodation of Muslim family law was, quote, unavoidable in England. His suggestion, though carefully qualified, prompted more than 250 articles in the world press within a week, the vast majority denouncing the suggestion and the Archbishop. England, the Archbishop's critics charged, will be beset by licensed polygamy and barbaric procedures and brutal violence against women encased in suffocating burqas. Muslim citizens of a Western democracy will be subject to legally ghettoized Muslim courts immune from civil appeal or constitutional challenge. Consider Nigeria, Pakistan, and other former English colonies that have sought to balance Muslim Sharia with the common law. The horrific excesses and chronic human rights violations of these religious courts, even ordering the faithful to stone innocent rape victims for dishonoring their families, prove that religious laws and state laws cannot coexist. Case closed, concluded the Archbishop's critics. This case won't stay closed for long. The Archbishop was not calling for the establishment of independent Muslim courts, let alone the enforcement of Sharia by English courts. He was instead raising a whole series of hard but unavoidable questions about marital, cultural, and religious identity and practice in Western democratic societies committed to human rights for all. What form of marriage should citizens be able to choose, and what forms of religious marriage law should states be required to respect? How should Jews and Christians and Muslims and other religious groups with distinctive family norms be accommodated in a society dedicated to religious liberty and self-determination, to religious equality and non-discrimination? Are legal pluralism and even a kind of personal federalism necessary to protect Muslims and other religious believers who are conscientiously opposed to the liberal values that inform modern laws of sex, marriage, and family? These and other hard questions are becoming unavoidable in many modern Western democracies with growing and diverse Muslim communities, each making new and ever more insistent demands. If current growth rates of Muslim communities in the West continue, a generation from now, the so-called Danish cartoon crisis is going to seem like child's play. Even democratic countries that share a common law heritage and a common commitment to human rights and religious freedom have taken quite different approaches to these questions. Let's take three countries: England, Canada, and the United States. England, of these three, has the largest group of Muslim minorities and has been the most accommodating of Muslim schools and charities and banks and arbitration tribunals. In particular, English courts have increasingly upheld the arbitration awards of Muslim tribunals in marriage and family disputes, so long as all parties consent to participate and so long as there's not a hint of any coercion or threat of the same. The same deference is accorded to the marital arbitrations of Jewish, Christian, Hindu, and other peaceable authorities. Canada, the most constitutionally liberal of these three examples, debated seriously a decade ago the recognition of independent Sharia marital tribunals in Ontario and then in Quebec, but ultimately rejected them in favor of single provincial laws for marriage and family questions for all of its citizens, Muslim and non-Muslim alike. But Canadian Muslims enjoy ample individual and corporate religious freedom and human rights exercises. The United States, though with sizable and diverse Muslim populations, has been the least accommodating of its Muslim citizens. American Muslim litigants have not fared well of late when they have challenged state denials of charters or exemptions for their schools, charities, or mosques, nor have they often succeeded in challenging prohibitions to wear traditional religious apparel while teaching in public schools or testifying in public courts or serving in public places. Most American state courts have only sporadically upheld private Muslim marriage contracts. They have often sided with non-Muslim spouses in divorce and child custody cases involving mixed marriages. They have always held a firm line against Muslim polygamy and have granted shrinking deference to arbitration awards or mediation settlements by Muslim tribunals or religious officials. But American Muslims have continued to agitate for greater religious freedom, autonomy, and self-determination in the marriage and family field. It's no surprise that it's the law of marriage and family life that has triggered this new contest between law and religion in the West. For marriage has long been regarded as both a legal and a spiritual institution, subject at once to special state laws of contract and property and to special religious canons and ceremonies. Marriage has also long been regarded as the most primal institution of Western society and culture. Aristotle and the Roman Stoics called the marital household the foundation of the republic, the private font of public virtue. The Church Fathers and medieval Catholics called it the seedbed of the city, the force that welds society together. Early modern Protestants called the household a little church, a little state, a little seminary, the first school of love and justice, charity, and citizenship. John Locke and the Enlightenment philosophers called marriage the first society to be formed as men and women came forth from the state of nature into an organized society dedicated to protection of their rights and the rule of law. Because of its cultural importance, marriage was also one of the first institutions to be reformed during the decisive battles between church and state in the West. In the 4th and the 5th centuries, when Constantine and his imperial successors converted the Roman Empire to Christianity, they quickly passed new marriage and family laws based directly upon Christian teachings. In the late 11th and 12th and 13th centuries, when Pope Gregory VII and his successors threw off their civil rulers and established the Catholic Church as an independent legal authority in Western Christendom, the Church seized jurisdiction over marriage, calling it a sacrament subject to the church courts and to the Church's canon law. In the 16th century, when Martin Luther, Henry VIII, and other Protestants called for reforms of church, state, and society, one of their first acts was to reject the Catholic canon law of marriage and the sacramental theology that supported it, and to transfer principal legal control over marriage and family life back to the state, the Christian magistrate. In the later 18th century, when the French revolutionaries unleashed their fury against traditional institutions, they took early aim at the Catholic Church's complex marital rules and roles and rituals, consigning marriage to the rule of secular state authorities alone. And in the early 20th century, when the Bolsheviks completed their revolution in Russia, one of Lenin's first acts was to abolish the legal institution of marriage as a bourgeois impediment to the realization of true communism. Modern Western democracies have not abolished marriage as a legal category, but they have dramatically privatized it and thinned out most of its traditional elements, such that marriage has become an easy-in, easy-out contract, and the differences between marital and non-marital sexual life and interactions are largely negligible and subject to private negotiation and control. Many Muslims living in the West decry the massive changes to prevailing state laws of sex, marriage, and family born of the new cultural and constitutional sexual revolution, and they want out. Some Muslims have gone back to their Muslim-majority homelands, shaking their heads in dismay at what Western libertinism has wrought. Others have stayed put and just quietly ignored the state's marriage and family law, using the shelter of constitutional laws of privacy and sexual autonomy to become a law unto themselves. Others have developed elaborate prenuptial contracts that seek to exempt Muslim couples and families from much of the state's law in favor of internal norms and practices of their own religious communities. Still others have led bicultural lives, dividing their time between Western homes and Muslim-majority lands that allow them to form Muslim marriages and families, including those that permit polygamy, patriarchy, and primogeniture. All of these informal methods of cultural and legal coexistence, however, are only temporary expedients that can easily fall apart. Eventually, a Muslim citizen will appeal to the state for relief from a religious marriage contract or a religious family practice that he or she cannot abide, but also cannot really escape. Eventually, an imam or a shadow Sharia court, which are already operating in the West, will overstep by using force or issuing a fatwa that draws the ire of the media and the scrutiny of state courts. Eventually, an aggressive state caseworker or prosecutor will move upon a Muslim household, bringing charges of coerced or polygamous marriage. Eventually, a Muslim school or charity will find itself in court faced with a suit for gender discrimination or child abuse owing to its practice of corporal punishment and single-sex education. And once such a major case or controversy breaks and the international media gets involved, many of these informal and temporary domestic arrangements might well unravel, particularly given the cultural backlash against Muslims prompted by 9/11, 7/7, Fort Hood, and the bloody and unpopular wars against Islamist extremism in Iraq, Afghanistan, and much of the rest of the world. It's precisely this vulnerability that advocates of faith-based family law and Sharia courts want to avert. They want to put Sharia family law and its voluntary use by Muslim faithful on firmer constitutional and cultural ground in the West. But rather than denouncing Western liberalism and the sexual, moral, and marital lassitude it has purportedly occasioned, sophisticated advocates now press their case for Sharia in and on the very terms of Western constitutionalism and political liberalism. In the vast burgeoning literature that's now available, three main arguments stand out. The first part of the case for Sharia is an argument for religious freedom. Why should peaceable Muslim citizens, the argument goes, not be given religious freedom to opt out of state laws on sex, marriage, and family that run afoul of their core claims of conscience or the central commandments of their faith? Why should they not have freedom to choose to exercise their domestic lives in accordance with their own faith traditions? Why doesn't freedom of religion provide a sincere Muslim with protection against, say, a unilateral divorce action or a child custody order by a state court that runs directly contrary to the rules of Sharia? Why doesn't freedom of religious exercise empower a pious Muslim man to take 4 wives into his loving, permanent care in imitation of the Prophet, particularly when his secular counterpart can consort and cavort freely with 4 women at once and then walk out scot-free? The second part of the case for Sharia is an argument from religious equality and non-discrimination. After all, many Western Christians do have religious tribunals to govern their internal affairs, including some of the family matters of their faithful, and state courts will respect their judgments, even if they are appealed to Rome or Canterbury or Moscow. No one is talking about abolishing these church courts or trimming their power, even after recent discoveries of grave financial abuses and cover-ups of gross clerical sexual abuse of children in some churches. No one seems to think that these Christian tribunals are illegitimate when some of them discriminate against women in questions of ordination or church leadership. Similarly, Jews are given wide authority to operate their own Jewish law courts to arbitrate marital, financial, and other disputes amongst the Orthodox Jewish faithful. Indeed, in New York State by statute and in many other states and European nations by custom, courts will not issue a civil divorce to an Orthodox Jewish couple unless and until the Bet Din, the Jewish law court, issues a religious divorce, even though Jewish law systematically discriminates against the wife's right to divorce unilaterally. If Christians can have their canon laws and consistory courts, if Jews can have their Halacha and their Bet Din, and if even Native American Indians can have their ancestral laws and tribal rulers, the argument goes, why can't we Muslims be treated equally in our use of Sharia and Islamic courts? The third part of the case for Sharia is an argument from political liberalism. One of the most basic teachings of classical liberalism is that marriage is a pre-political, a pre-legal institution. It was not created by the state. It comes before the state and its positive laws, both in historical development and in ontological priority. As John Locke put it famously in his 2 treatises on government of 1689, the marital contract was the first contract, the first society to be formed as men and women came forth from the state of nature. The broader social contract came later, presupposing stable marital contracts. And contracts to form state governments or religious institutions or other voluntary groups came later still. Why, on this simple contractarian logic, should the state get exclusive jurisdiction, lawmaking power over marriage and the family? After all, it was 16th century Protestants, not 18th century Enlightenment liberals, who first vested the state with marital jurisdiction. But why is state jurisdiction over marriage mandatory or even necessary? Before the 16th century Protestant Reformation, and in many Catholic lands after the Reformation too, the Catholic canon law and Catholic church courts governed marriage. Moreover, even in Protestant England until the 19th century, the state delegated to church courts a number of marriage and family questions. There is evidently nothing inherent in the structure of Western marriage and family law that requires that it be administered by the state. And there's nothing ineluctable in liberalism's contractarian logic that requires marital couples to choose the state rather than themselves or their families or their religious communities to govern their domestic lives, particularly when the state's liberal rules diverge so widely from their own beliefs and practices. On this latter argument, conservative Muslims sometimes join hands with selected Christian conservatives and critical liberals who call for the exemption from, if not the abolition of, state marriage law. Conservative Christians because the state has betrayed traditional Christian teachings on marriage. Critical liberals because the state is still encroaching on sexual autonomy and privacy. There's a lot more to the arguments, but those are the 3 main arguments you see in the literature today. And let's sort through these arguments and see how they pan out. The problem with the first pro-Sharia argument from religious freedom is that it falsely assumes that claims of conscience and freedom of religious exercise must always trump. But that's hardly the case in modern democracies, even though religious freedom is widely cherished. Even the most sincere and zealous conscientious objectors must pay their taxes, register their properties, answer their subpoenas, obey their court orders, swear oaths, or give other proofs of veracity, and abide by many other general laws for the common good that they may not in good conscience wish to abide. Their eventual choice, if they persist in their claims of conscience, is to leave the country or to go to prison for contempt. Moreover, even the most devout religious believer has no claim to religious exemptions from criminal laws against activities like polygamy or child marriage or female genital mutilation or corporal discipline of wives, even if their particular brand of Sharia might command it or their particular religious community might commend it. The guarantee of religious freedom is not a license to engage in crime. Muslims who are conscientiously opposed to liberal Western laws of sex, marriage, and family are certainly free to ignore them. They can live chaste, private lives in accordance with Sharia and not register their religious marriages with the state. That choice will be protected by constitutional rights of privacy and sexual autonomy, so long as those relationships are truly consensual. But that choice also leaves their family entirely without the rights, privileges, and protections available through the state's complex laws and regulations governing marriage and family, marital property and inheritance, social welfare, residual life insurance, Social Security, and much, much more. And if minor children are involved, the state will intervene to ensure their protection, support, and education, and will hear nothing of religious freedom objections from their parents or from community leaders. Western Muslims enjoy the same religious freedom as everyone else, but some of the special accommodations pressed by more zealous, intense Muslim Sharia advocates today in the name of religious freedom are simply beyond the pale for most Western democracies. Even further beyond the pale is the notion of granting a religious group legal sovereignty over the domestic lives of their voluntary faithful, a pressure point where a number of the most zealous Sharia advocates are moving. It's one thing to allow religious officials to officiate at weddings, to testify in divorce cases, to assist in the adoption of a child, to facilitate the rescue of a distressed family member, and the like. Most Western democracies readily grant Muslims and other peaceable religious communities those kinds of accommodations. Some democracies will also uphold the religious arbitration awards and mediation settlements over discrete domestic issues. But that's a long way from asking the state to delegate to a religious group legal power to govern the domestic affairs of their members in accordance with their own religious legal system. No democratic state can readily accommodate a competing sovereign to govern such a vital area of life for its citizens, especially since family law is so intricately interwoven with so many other public, private, penal, and procedural laws. Surely a democratic citizen's status, entitlements, and rights cannot turn on the judgments of a religious authority that has none of the due process and other procedural constraints of a state tribunal. Moreover, the proud claims, and the justifiably proud claims, of Muslim advocates that Sharia provides a time-tested and comprehensive family law system is for some an even stronger strike against its accommodation. Once a state takes the first step down that slippery slope, skeptics argue, there will eventually be little to stop the gradual accretion of a rival religious law over sex, marriage, and family, particularly as Muslim communities grow stronger, larger, and more politically powerful. Some Western states thus resist even religious arbitration and mediation of marital disputes by Muslim tribunals. Oklahoma passed a state constitutional amendment to this effect 2 years ago. 12 states stand poised with comparable measures. The pro-Sharia argument from liberal contractarian logic, the argument that says since marital contracts are pre-political, coming before the contracts that form society, the state, and religious authorities, parties should be free to choose which law governs them. That argument is clever, but it's incomplete. It ignores another elementary teaching of classical liberalism, namely that only the state and no social or private unit can hold the coercive power of the sword. The government contract does grant this coercive power over individuals to the state, but only in exchange for strict guarantees of due process of law, equal protection under the law, and respect for fundamental rights of all. A comprehensive system of marriage and family law, let alone the many correlative legal systems of inheritance, trusts, family property, children's rights, education, social welfare, and more, cannot long operate without coercive power. It needs police and prosecutors and prisons, subpoenas, fines, and contempt orders, material, physical, and even corporal sanctions. Moral suasion and example, communal approbation and censure can certainly do part of the work. But in our modern, porous, transient society, where citizens enjoy a fundamental right to travel, no less, a properly functioning marriage and family law system requires resort to all of these coercive instruments of government. And only the state, not a religious body, can properly use these coercive instruments in a modern democracy in exchange for strict due process constraints. The pro-Sharia argument from religious equality and non-discrimination, since Christians and Jews and others have their tribunals, we'd like to have ours too, takes a good bit more effort to parry. A useful starting point is the quip of U.S. Supreme Court Justice Oliver Wendell Holmes, Jr., who wrote, "The life of the law is not logic, but experience." This adage has bearing on this issue. The current accommodations made to the religious legal systems of Christians and Jews and Native American Indians and others in the West were not born overnight. They came only after decades and sometimes centuries of hard and cruel experience, with gradual accommodations and adjustments made on both sides. The accommodation of and by Jewish law to Western secular law is particularly instructive in this regard. It is discomforting, but essential to remember that Jews were the perennial pariahs of the West for 2 millennia, consigned at best to second-class status and periodically subject to waves of brutality, whether imposed by Germanic purges, medieval pogroms, early modern massacres, or the 20th century Holocaust. Jews have been in perennial diaspora after the destruction of Jerusalem 2 millennia ago, living in a wide variety of legal cultures in the West and well beyond. One important legal technique of survival they developed after the 3rd century of the Common Era was the concept of dina da machuta dina. The law of the community is our law. This meant that Jews accepted the secular law of the legitimate and peaceful secular ruler who hosted them as the law of their own Jewish community, to the extent that it did not conflict with core Jewish laws. This technique allowed Jewish communities to sort out which of their own religious laws and customs were indispensable, which more discretionary, which secular laws and practices could be accommodated, which had to be resisted even at the cost of life and limb. This technique not only led to ample innovation and diversity of Jewish law over time and across cultures, it also gave Jews the ability to survive and to grow legally even in the face of ample persecution. Western democracies, in turn, particularly in the aftermath of the Holocaust and in partial recompense for the horrors it visited upon the Jews, have gradually come to accommodate core Jewish laws and practices. But it's only in the past 2 generations, and only after endless litigation and lobbying, that Western Jews have finally gained legal ground to stand on. And even that ground is still thin and crumbles at the edges at times. Today, Western Jews generally have freedom to receive Sabbath day accommodations, to gain access to kosher food, to don yarmulkes and other distinctive grooming, to get charters for their schools and synagogues and charities. And Jewish law courts have gained the right to decide some of the domestic and financial affairs of their faithful, who voluntarily elect to arbitrate their disputes before them rather than suing in secular courts. These Jewish law courts are attractive to Jewish disputants because they are staffed by highly trained jurists, conversant with both Jewish law and secular law and sensitive to the bicultural issues that are being negotiated. Unlike their medieval and early modern predecessors, these modern Jewish law courts claim no universal jurisdiction over Jewish life, and they have abandoned their traditional authority to impose physical sanctions or coercion on their disputants. In particular, they claim no authority beyond persuasion to stop a disputant from simply walking out of Jewish court and out of the Jewish community altogether. The modern lessons in this story for Sharia advocates are three. First, it takes time and patience for a secular legal system to adjust to the realities and the needs of new religious groups and to make the necessary legal accommodations. The hard-won accommodations that modern Jewish law and culture now enjoy are not fungible commodities that Muslims or any others can claim with a simple argument from equality. These are individualized, equitable adjustments to general laws that each community needs to earn for itself, based on its own needs and experiences. Muslims simply do not have the same record of persecution that the Jews have faced in the West, and simply do not yet have a long enough track record of litigation and lobbying. Concessions and accommodations will come, but only with time, with patience, with persistence. Second, it takes flexibility and innovation on the part of the religious community to win accommodations from secular cultures, if not laws. Not every religious belief can be claimed as central. Not every religious practice can be worth dying for. Over time, and of necessity, diaspora Jewish communities learned to distinguish between what was core and what more penumbral, what was essential and what more discretionary in Jewish legal and cultural life. Over time, and only grudgingly, Western democracies learned to accommodate the core religious beliefs and practices of Jewish communities. Diaspora Muslim communities in the West need to do the same. Islamic laws and cultures have changed dramatically over time and in different parts of the world. And modern-day Islam now features immense, diverse, and sophisticated variety in its legal, religious, and cultural practices. That diversity and that sophistication and the adaptability that comes with it provides ample opportunity and incentive for Muslim diaspora communities to make the necessary adjustments to Western life and to sort out what is core and what is more discretionary in their religious lives. Cultural adaptation, not cultural assimilation, is what is needed to win accommodations. Third, religious communities, in turn, have to accommodate, or at least tolerate, the core values of their secular host nations if they expect to win concessions for their religious courts and other religious practices. No Western nation will long accommodate, perhaps not even tolerate, a religious community that openly denounces and seeks to undermine its core values of liberty, equality, and fraternity, or human rights, democracy, and rule of law. Those who wish to enjoy the freedom and the benefits of Western society have to accept its core constitutional and cultural values as well. So far, only a small and brave band of mostly Western-trained Muslim intellectuals and jurists have called for the full embrace of democracy and human rights in and on Muslim terms. These are highly promising arguments, courageously proffered. Even more promising are the growing numbers of second, third, and fourth generation Muslim citizens, brothers and sisters in our midst who have learned to live both as Muslim faithful and as American citizens. More promising still are the new democratic experiments erupting now in the Arab Spring around the Mediterranean and in many other parts of the world that hold promise, at least, for a new way. But even the most liberal and optimistic Muslims today are still hard-pressed to point to modern examples of a Sharia-based legal system that maintains core democratic and human rights values. Until that case can be reliably made out, deep suspicion will remain the norm. Lest all this seem like an unduly patronizing, pat-on-the-head argument for religious minorities to wait and see or change and hope for the best, it's worth remembering that majority Christians, too, went through much of this same exercise in the area of religion and education. The American story provides a good illustration of how this developed and how common educational standards were eventually raised and maintained. In the later 19th century, a number of American states wanted to have a monopoly on education in public or state-run schools. A growing amount of this agitation was driven by anti-Catholic animus. Catholics in the later 19th and early 20th century were in a position comparable to how our Muslim friends are treated today. They were pilloried, they were derided, they were criticized in state legislative floors, they were subject of horrific dicta in state courts. Authorities turned a blind eye to the violence against their monks and nuns in cemeteries and sanctuaries. They were pariahs in the West, not welcome. They were strange. They had a foreign leader sitting in Rome. And part of the agitation of anti-private religious schools was driven by this. And for almost a century, Catholic churches and schools and religious parents struggled earnestly to protect their rights to educate their children in their own private religious schools. And in the landmark U.S. Supreme Court case of Pierce versus Society of Sisters in 1925, the Supreme Court finally held for the churches and ordered American states to maintain parallel public and private education options for their citizens. But in a long series of cases thereafter, courts also made clear that states could set basic educational requirements for all accredited schools, mandatory courses and texts, minimal standards for teachers, students, and facilities, common requirements for labs, libraries, gyms, and more. Religious schools could add to the state's minimal requirements, but they could not subtract from them. Religious schools that sought religious liberty exemptions from these accreditation requirements found little sympathy from the courts, who instructed the religious schools either to meet their standards or to lose their accreditation and licenses to teach. This compromise on religion and education, forged painfully over a century of wrangling, has some bearing on this question of religion and marriage. Marriage, like education, is not a state monopoly, even if marriage law must be a state prerogative. Religious parties in the West have long had the right to marriage in a religious sanctuary following their preferred wedding liturgies. Religious officials have long had the right to participate in weddings, annulments, divorces, child custody battles of their members. But the state has also long set the threshold requirements of what marriage is and who may participate. Religious officials may add to these threshold state law requirements on marriage, but not subtract from them. A minister may insist upon premarital counseling before a wedding, even if the state will marry a couple without it. But if a minister bullies a minor to marry out of religious duty, the state will throw him or her in jail. A rabbi may encourage a bickering couple to repent and reconcile, but he cannot prevent them from filing for divorce. An imam may preach of the beauties of polygamy, but if he knowingly presides over a polygamous union, he's an accessory to crime. If religious tribunals do get more involved in marriage and family questions over the next generations, states may well build on these precedents and set threshold requirements in the form of a license and accreditation order, formulating these license rules through a democratic process. Amongst the most important license rules to consider for such tribunals, no child or polygamous marriages, no compelled marriages or coercions before weddings that violate elementary freedoms of conscience and contract, no threats or violations of life and limb or provocations of the same, no blatant discrimination against women or children, no violation of basic rules of procedural fairness. Religious tribunals may add to these requirements, but they may not subtract from them. Those who fail to conform will lose their licenses and will find little sympathy when they claim religious liberty exemptions in courts. This type of arrangement worked well to resolve some of the nation's hardest questions of religion and education, and it led many Catholic religious schools over the past century slowly to transform themselves from backward sectarian isolationists into exemplary cultural leaders who are now ruling the land. Muslims in the West have already begun some of this exercise too, in the development of Muslim grade and high schools, which are now the envy of many neighborhoods in our big cities. Such a comparable arrangement might be possible in the religion and marriage area. Such an arrangement holds the promise of avoiding the descent to licensed polygamy and barbaric procedures and brutalized violence that the Archbishop's histrionic critics were portending. But it also holds the promise of encouraging those forms of Muslim marriage and family law that are most conducive to Western norms and cultural patterns. And who knows, maybe a century from now, Muslims will be teaching all of us in America what a faithful marriage and family law system looks like. Thank you very much. So now the fun part starts. And I would normally come to you to be polite and stand beside you when you spoke, but I have to stand at this lectern to answer to be on film. My malpractice needs to be recorded for the insurers. Surely there are questions. Gentleman here.
I guess taking your tripartite analysis, can you extend that out towards contracts in criminal law? Is there a common interest here beyond your notion of core values of a society that will allow this kind of integration and an accommodation of a mass of cultures here?
Yeah, I think there have to be some non-negotiables, and criminal law certainly is one. Privatizing the criminal law system and leaving criminal law to be enforced by a variety of local groups with or without state sanction, I think, is a danger point that we simply cannot go. That's balkanization rather than pluralization. In the marriage and family field, we have one of three prime examples in American society and indeed in the history of the West where we have shared jurisdiction. These are called the classic res mixta of the West. Marriage and family is one, education and schooling is a second, and charity and social welfare are a third. These are institutions, activities in society that have both spiritual and temporal dimensions, where religious and political authorities have always shared and always contested jurisdiction. What has emerged over the past 100+ years until recently is that in the area of education, we have learned to share, apropos the story that I just told at the end. In the area of charity and social welfare, after the modern welfare state in the 1930s and 40s began to emerge, we looked to the state to do a great deal of the social welfare work that was organized. Voluntary religious and non-religious private communities participated, but with far less alacrity. We're now renegotiating that, in part because constitutional laws changed, faith-based initiatives and other ways of thinking about cooperation between religious and state authorities is becoming possible again, but also out of necessity. The modern social welfare state as we know it today is no more. It's basically dying with fraying social welfare nets around the country and around the West. And it's not clear that that fraying is going to be repaired anytime soon. We are thus looking to new kinds of ways of thinking about religious and political communities sharing power, jurisdiction, resources, programs. And the final one, which is the hardest one in many ways, that's just over the horizon, as I indicated, is in this religion and marriage area. We have assumed since the French Revolution in Europe and really since the mid-19th century in America that the state rules the family, with a few notable exceptions for Jews and Native American Indians and a few grudging exceptions to other small groups. But the thought is marriage and family law is a state monopoly. And what we're doing now, I think, is starting to rethink that, in part out of privatization arguments, in part out of shared jurisdictional understandings in other areas of life, in part out of necessity in modern multiculturalism and pluralism pressures, in part out of dissatisfaction on the part of a portion of the population with the increasingly thinned marriage and family system offered by the state. And I think in this area, we're going to see a recalibration of that social system under religious and political authority. Outside of those three areas, I don't see the ineluctability of the privatization argument that some of my more zealous colleagues, intense colleagues, would suggest. Other questions? There's a microphone coming to you, sir, or madam, with two in a row here.
Yes, thank you very much. It was an exciting lecture, a new construct that you put forth for me to think about.
Thank you for the exciting lecture part. I'll bring that home and get some credibility at my supper table with my dear bride.
Well, on this last Q&A, you brought up the point about charity as the third area, category, which brings up an interesting question. I'd like you to speak to what are some, you say like to have more of a religious groups doing charitable work. Now, what are some of the challenges there? Because we're beginning to see them of religious groups imposing their religious tenets onto other people, citizenry.
Sure.
And
so that's the hard part, right? When the state's in the business of spending the people's money and using a private religious organization to dispense the service to the needy or the deserving in the community, to what extent can the state impose conditions upon how that money is spent? And what we do in the faith-based initiative programs at the state and at the federal level is say this: you guys don't have to take our money. You can do all the charitable service you want. We'll give you 501c3 status, so you can collect all of your charitable contributions. You get 170 deductions. We can give you charitable organization and corporation, and you can just run your own show. And you can be as discriminating as you want. You can condition the soup kitchen attendees' receipt of soup to attending the Mass or attending the Torah reading. You can do that. The question is when you're spending the people's money, tax money, may the government say, there are certain things you can't do. And I think that the proper response is, yes, because you are acting on behalf of the state and can't do things that the state can't do. So you can't discriminate. You can't say if you have say a Baptist Alcoholic Anonymous program, only Baptist drunks can apply. Everybody in the community has to allow it, right? You can't say, as a condition for receipt of our services, which the taxpayers paid for, and that are available for you to come over your addiction and to come back into full participation in public and private life, we can't say to you, the only way you're going to be able to get our service is by participating in the Sunday worship service. If you do that, you are violating the free exercise rights of the individual citizen whose services are being paid for by the taxpayer. Questions then become closer to the edge. Do you have to shroud the crosses? Do you have to hide the Torah scrolls? Do you have to mute the call to prayer when the recipient of the aid comes within your community? And those are questions at the edges that you do. They're hard to write universal rules about this. I think passive versus active options in the community for the party to receive his or her service from somebody else as opposed to you, religious charity, I think are important considerations to take into account there. Please.
In talking about recalibration and edges, is it clear which problems are best handled by the legal system and which problems are best handled in the political arena?
Say a little more. Which prongs?
Which problems that you're dealing with in marital law and charitable education, which problems, most of the education, for example, cases have mainly been handled, I think, in the legal arena. Are they all looking forward, the other ones also handleable in the legal arena, or would they be better handled in the political arena?
The line between political and legal regimes, of course, is a very porous one, and much of the politics is driving toward the creation of a law, whether a piece of legislation or a regulation or a case. And so politics and law do go hand in hand, and my critical legal studies teachers 30 years ago would tell you that the same thing. There is a difference, but the difference is porous. I think the harder question is do you do this by federal law versus state law? Do you do this by adjudication as opposed to legislation? Which level and which branch of government is in the better position to do this? If you do it by federal, especially constitutional law, which we have done in the religion and education area, you're imposing, or at least dealing with a hard constitutional law system, as opposed to a more soft local legal system. And those are terms from Larry Kramer and some of his interesting work on point, the ex-dean of Stanford Law School. Soft law versus hard law, hard big C constitutional law as opposed to soft negotiated, you can call it politics, but really negotiated law that doesn't necessarily give rise to cases. I think in this area of marriage and family, it's much better to make these adjustments gradually. A soft law approach, a local approach, certain procedural non-negotiables in place, certain things that simply cannot go even if a sparsely populated Western state would like them to go. I think it's pretty obvious to me, as it was to the U.S. Court of Appeals, that the state constitutional amendment in Oklahoma that said state courts in Oklahoma may not use Sharia in any cases that come before them is patently unconstitutional. That's just singling out a particular religious community and saying, we don't like you and we don't like your laws. You can't do that. That's just a blatant violation. So doing it by that kind of constitutional fiat is dangerous. I think in this area, we're going to need gradualism. We're going to need conversation like the ones we're having here. We need democratic ventilation of these issues. We need local experimentation. In the marriage and family law area, for the most part, still is a state exercise rather than a federal exercise. And I think that's healthy. It's going to take a few generations to work this out, and I think establishing the non-negotiables up front and having a clear sense of what's permissible and impermissible, what other countries have done and what other areas of law have achieved are useful prototypes on which to call. Please. There's a microphone coming your way.
Thanks. Thank you for your presentation. I have a question about the way you define Sharia.
Yeah.
Coming from Morocco, I mean, we have a constitution and we say that it's based on the Sharia and it's That's the basic influence is the Sharia. But I mean, in Egypt, in Tunisia, and the rest of the Arab world, there is still the question of Sharia being something fluctuating. Even in the history of the Ottoman Empire, it was never, this is the law. It was through time that it was, some parts of it were studied and analyzed and then examined every single time, because even as a basic, the premise of Sharia comes from ijtihad, of people studying the Quran and seeing what basically can be adapted to society, and because it means the way towards the divine light.
Yep.
So I have trouble because not only is it demonized in the Western world, but it also seems as if people speak about Sharia as being something very defined, which is not at all the case. Yeah, if you could provide
Excellent point. Excellent point. How many? About 2 billion Muslims in the world, 13 schools of jurisprudence, hundreds of different sub-schools within those 13 schools, all of which are under the label called Sharia. Sharia sometimes operating independent of the state, in 57 Muslim-majority countries operating with state sanction and bent, distorted even more by that exercise. And so we have to be very careful in the West, and you're proper to rebuke me about being very careful in my presentation, to talk about, look, Sharia is not just a one-size-fits-all. There is a variety of forms of Sharia. It's an evolving, living legal system. Living legal systems adapt and change, and it's precisely that diversity, at that growing quality, that adaptability, which I lift up as one of the expedients for our Muslim brothers and sisters in the West. The argument being that there's not a one-size-fits-all that you took from your homeland that now has to be imposed on all of your fellow Muslim emigres. There's variety in your own community, there's variety in the Muslim community, the Ummah writ large. And by consequence of that, there is an invitation for those in the West to look at that diverse Muslim set of Muslim legal norms and practices and procedures, evolving though it is, and to pick those that have the most portability, transportability, adaptability for a person living in the West to be faithful to his or her Muslim community and faithful to the oath of being an American citizen. And that is possible. And indeed, some of the interesting work that's being done in the last 10, 15 years, including by my colleague Abdullahi Al-Naim, is driven exactly by that calculus. And it's that diversity, I think, that gives us the greatest hope that in a nation of immigrants, where we always eventually accommodate newcomers in our midst, that gives us the greatest hope that our Muslim brothers and sisters amongst us also will be accommodated. Madam, please.
Tom Timberg, the one thing of very impressive presentation, I was interested in your talking about the need to work out, if you will, the boundaries between the states, right? But it seems to me that there is a fourth area in which we are dealing with things, and the principle there, I think, is usually a question of, if you will, minimal disturbance, and that's the commercial area. We haven't worked it out entirely, but for example, the Comptroller of Currency has issued indications that if Islamic financial transactions are substantially equivalent, they will be treated equivalently, even though their, if you will, their form is somewhat different. The issue here is that they don't like banks owning buildings, but an Islamic mortgage often involves the bank being the owner of record. There are similar issues for Jews with this Sabbath limits around communities, which again, the forms involve acquiring ownership, but the substance doesn't.
Thank you, Tom. That's a very good point. I'll let it stand as a very provocative point, and I mean that sincerely. I think it's an interesting insight I haven't thought of, and I'm going to think about it some more, and maybe in conversation with you, I'll give you my card so we can chat some more.
What I'm struggling with, and I agree, this was fabulous, presentation, but if you talk about education and even social services, the licensing by the state or the setting limits has nothing really to do with the fundamental precepts of the religion. And where I get worried is that if you talk about family law that's structurally different from what would happen in a US court, what you're going to be evaluating is somehow an entanglement with the religious precepts, the fundamental precepts. And I just wondered if you could comment on whether you think that really can be done under our system.
Yeah, that's a nice term, entanglement, because that, of course, as you know, is the third prong of the Lemon test used for Establishment Clause jurisprudence. Congress shall make, or states now shall make no law establishing religion. One of the ways we discern whether there's an establishment of religion is if there is, quote, excessive entanglement between religious and political authorities. So the system of marriage and family law being done by states, one option, religious communities, another option, is predicated on the starting assumption that we're trying to avoid entanglement rather than create entanglement. Thought being here, religious communities have to be given the right to do things on their own, and their voluntary faithful have to be able to avail themselves of that legal system without interference by review of their judgments by the state. Now that's the excessive entanglement argument is the argument that is pushing, in part, this jolly new system that we're contemplating. Secondly, we do this already in the arbitration area. Arbitration is an extrajudicial means of resolving disputes that parties can contract into. When there are commercial disputes, as Tom will tell us more, when there are other kinds of disputes, family, neighborhood, association disputes, parties can agree to binding arbitration. And binding arbitration, which is licensed by the government, the Federal Arbitration Act and state equivalents are in the business of policing that activity, and those arbitrators, once licensed, are permitted to give final decrees, largely unreviewable, some review, tepid review, but largely unreviewable by the state. Increasingly, in the religious arbitration area, Christians, Jews, Muslims, Mormons, Hindus, and others are beginning to arbitrate in accordance with their own religious legal systems, and dealing not just with marriage and family, they're dealing with finance, they're dealing with banking, they're dealing with all kinds of corporate interesting issues out there, and the states basically are in the position with tepid, marginal procedural review to say, thank you. So we're doing this a little bit already. But now here's, I think, the heart of your point, even if we can wiggle out of the entanglement and precedent grounds. The heart of your point is whether we start with the premise of the state is the lawgiver for marriage and family, or the individual is the lawgiver for marriage and family. And I think that's what's being renegotiated today. Is it the state that says, here are the rules, this is how you participate, here are the forms, this is how you get dissolved, here are the default rules, and you can have a private prenuptial contract to contract out, but if you don't do it or don't do it right, the state's default rules set in. Is that the starting point? Or is the starting point, no, actually it's the individual who chooses. Now, 46% of couples living under the age of 50 have said, I don't want the state. Why? Because I'm living without marriage. And that's basically a tacit seizing of jurisdiction. It's dangerous in my view. I mean, it's a Wild West frontier without laws unless you're pretty good at prenups. But the danger of making that a law unto yourself is that some people don't have the sophistication to create the internal legal system. Now, when you get into charity, when you get into education and other areas, those very same questions, I think, have to be negotiated too. You look unhappy, so go back. Fire away some more. No, you fire away.
Oops, I'm sorry. That's fine, except as I'm sure you know and most everybody here, the problem in family law is those agreements fall apart or you have an impact on children who may have independent rights for whom the state is responsible.
Yep.
So to say that, I'm making this up,
Yeah.
parents can agree that because of our religious faith, girls
Yep.
can't go to school after
Yep.
8th grade.
Right?
And if then later the child wants to go to school, it would be very hard to say that the state has to observe that, although admittedly we do that with the Amish. I mean, that's come about. So it's the fact that once you have a conflict, you're dealing in areas where you're getting to fundamental beliefs on one side and state protection and rules on the other. And I'm just having a hard time wrapping my head around it.
Yeah, it's a hard one. And you put your fingers exactly on the Achilles heel of this wonderful, brave new world that we're talking about, which is that there are vulnerable parties in domestic relations. Sometimes they are the adult spouses or partners participating, but more frequently, they are the kids. And the state does have a role to step into the shoes of, in loco parentis, as we call it, to stand in the shoes of the state, of the parent, to do things for the kid that the parents themselves may not want to do, and indeed may object to doing because of their religious convictions. I happen to think the Yoder case was a case on its own bottom, and it's become the genesis of the homeschooling movement, which I think is an unnecessary fruit of that case. It was a narrower case than it's become in the educational world.
We got time for a couple more, and our colleague here from the law library has a pressing question.
I'm in trouble now.
It's not a question, just a comment. I do agree with the previous question that it seems to me there is a difference between arbitration, as the person sitting in front of me noted, in the case of commercial issues where parties may agree for a different jurisdiction to apply to their issues, and matters that relate to family issues. It's not only the children, it's women, and the question of consent. What is a real consent that is required in order to undertake jurisdiction of a specific family law? You brought some examples. The New York law that you mentioned actually is designed to help in a specific problem that exists under Jewish law. And I was wondering, you mentioned that you studied the laws or family law application in the West, and you mentioned the United States, Canada, and the Ontario arbitration bill that fell apart, that was objected to. I think that it is very telling also to look at examples of how religious law is applied in countries where there is religious sort of pluralism, such as India and Israel. How do these countries apply religious law? And this will be very telling. I do agree with you that looking at the state as the initial origin of the law is very important, because there are certain principles that should guide any litigation or any treatment of enforcement or application of family law, especially with regard to all the parties involved, specifically women and children.
Yep.
Thank you.
So excellent comment. It'll mostly stand as an excellent comment with two glosses. Number one, I think you're absolutely right that in the marriage and family arena, consent, eyes wide open consent by all parties, is indispensably important. And what I mean by that is that far too often parties, women disproportionately, are pushed, coerced, nudged, sometimes forced into marriages as a matter of religious duty. They accept the jurisdiction of a religious tribunal and really don't have an opportunity to opt out. And I think that, in the Western context at least, is a critical point of review that I would raise even in an arbitration context.
If I may also comment, intent is not only being forced into acceptance of the family law, but the question is, in many communities, take the Amish community, it is well known that at the age of 16, I believe, in this country, the Amish community will let its members go to the city, go and choose if this is the lifestyle or that you want to adopt. And in almost all cases, they go back to the community. The same applies to communities, the Jewish community, the Muslim community, other religious communities. The consent issue is very complicated. It's not just merely that the society forces it on them. It's that particular individual that feels that they should abide by that, by the rules of the society. Yep. And that can contradict, can clash with state or constitutional principles of a country like the United States.
Good. Thank you. Dr. Brown is telling me our time's up. Let me just make that second gloss ever so briefly before she pulls me from the stage. Yes, I have studied other nations that have tried this pluralism model. South Africa is a recent one that in its constitution privileges customary law by both native groups in various tribal groups in South Africa, Muslim groups, Jewish groups, and others. It's very much a robust pluralism model, self-selected with a default being that you go to the state unless you pick a community. In India, it's a more robust pluralism system that says you have various styles of Hindu courts, Muslim courts, and you got to pick one. You don't have another opportunity. If you're a Christian, a non-believer in either of these two communities, you're still going to have your marriage and family questions adjudicated by one of those two bodies. That's a more robust form of pluralism that I think is inconceivable in the immediate future, at least of the United States. Final point, in Israel. I gave a variation on this chat when my respondent was Chief Justice Barak of the Israeli Supreme Court, now a professor at Herzliya. And he listened politely. He was nodding and nodding and nodding. I thought, oh, this is great. And his response was, are you crazy? Are you crazy? I mean, how can you possibly contemplate this? Because what you are contemplating is putting a nation on a slippery slope that eventually puts them in a position that I've been fighting the last 30 years, fighting with the chief rabbi. Every marriage and family question, the chief rabbi has final authority. And I'm a merely chief justice of the Israeli Supreme Court and have nothing to say. That's crazy, he says. Do not give religious authorities an inch in this field, because they will inevitably monopolize. That's a parade of horribles that also has to be amongst the things we contemplate as we get into this dicey area of faith, freedom, and family. Thank you so much again for your attention.
This has been a presentation of the Library of Congress. Visit us at loc.gov.